Court of Appeals for City Division and now in session. The Honorable Mark T. Booker, the Honorable Adrian N. Young, and presiding the Honorable Christopher B. Dix. All persons have been in hearing draw near. Your petition shall be heard. The United States of the United States, the state of Michigan, this honorable court, please be seated.
Welcome, everyone. Before we get started, I want to apologize for the slightly delayed start. It's entirely my fault. I got hung up in traffic. I stayed in Lansing last night and still couldn't make it to court on time. So sorry about that. I'm excited to be here this morning with my colleagues, Judge Boonstra and Judge Young. We had a good call yesterday. This is day 2. We are panel 6. And I just have a few instructions for you before we get started this morning. First of all, if you are dividing time, please tell us how you want to do that. Arguments, as you know, are 30 minutes aside, but if you're unopposed, you only get 15 minutes. And so if there are multiple people arguing on one side of a case, tell me how you want to divide your time before you get started, and I'll keep track of it for you. Also, if you want some time for rebuttal, just let me know. I'll keep track of your time for that as well. We have a fair number of cases today involving minor children. I want to remind all of you, please don't say the names of children during the course of the oral argument. All of our arguments are live streamed and they're archived, so you can go back and watch your own performance if you like, or you can watch the whole show if you can't stay till the end. So with that, I think we're ready to begin. Let's start with case number 15, docket number 373438. It's the People versus Nathaniel Bedgood. And I believe, Ms. France, you are here unopposed today, and so you get your 15 minutes, and obviously you don't need to reserve time for rebuttal. There'll be nothing to rebut.
Thank you, Your Honor. Judge Boonstra, Judge Young, Judge Yates, good morning. Jennifer France and Sue St. Marie on behalf of Mr. Bedgood.
Thank you for being here. My gosh, you get to take home the flowers for the longest trip here.
I get to drive back to the blizzard, I hear.
Oh, no.
Yes. Well, snow finally hit the UP, so it took a minute. I did want to give you all an update. Mr. Bedgood is now released on parole. He's doing very well. But that does change my prayer for relief. I would be asking for the court to vacate his conviction at this point, now that we're past him sitting in the prison system. I know you guys have had this briefed very, very well, so instead of regurgitating everything, I would ask if there are any questions.
Given his current circumstance, how do you feel about the case going back for a Ginther hearing?
I think it's important for a lot of reasons that we would do that, Your Honor. One, the only way we get better at practicing law, because it is a practice, is learning from our mistakes. And in this case, it was a grave mistake, and I feel awful for sister counsel. I mean, this is not something I enjoy. There's very few of us in the UP, and we're kind of a family up there. But unfortunately, we do have to work on educating on these types of defenses. And I think it's important that we explore everything that this court thinks is appropriate to move forward to make a better defense bar. So
it certainly is the case that your client is entitled to challenge the validity of his convictions. No doubt about that.
Yes.
Okay.
Yes, I agree, Your Honor.
And my understanding of the lower court record was that the prosecutor stipulated to the Ginther, but the trial court denied it.
Correct.
Okay.
Thank you all.
Thank you so much for coming down.
Yes, thank you.
Safe travels home. That
Thank
can be
you.
a harrowing drive.
Have a great day, you guys.
Thank you. That case will be submitted. Moving on now to case number 16, docket number 367303. This is the People versus James Byers. And I believe that we have a request for a remote oral argument for the appellant. So if you'll wait just a moment, we'll have counsel for the appellant on board. And I see that counsel for the appellee has taken a seat at counsel table. Good morning, counsel. And whenever you're ready, you may proceed. Can you hear me clearly?
Yes, I can hear you clearly. Thank you. And good morning to all of you. I did not make the Harrowing drive to Lansing, so I apologize for that. My name is Cecilia Kirandongo, and I represent Mr. Byers on appeal. I know this panel has read the record. It's a pretty extensive briefing of the three issues. I wanted to just touch on a few things. I understand that, we presented the ex post facto argument in regards to 76827A. I do understand what the state of the law is, but Mr. Byers did want to preserve that in case this court, deemed appropriate to overturn previous law, and make some different rulings. And he did, want to preserve that for any further appeal.
Right,
I
when you say
did.
ex post facto, you're talking about the admission standards for the other acts evidence, not this case itself, right?
That is correct. That is correct. Um, because at the time, the admission standards were different. So at the time of the offense, they were different. And I'm very, keenly aware of what the case law is currently. So, the argument is presented and preserved unless, of course, this court wants to, overturn precedent. In regards, yes, one can always try, right? If we
Yeah,
don't try, we never get
unfortunately,
anywhere.
that's not within our discretion.
Yes. So I did want to touch a little bit. So the arguments basically for the 404B evidence, there was never a balancing test done, and I do think that that was error to not do the balancing test. The court just it stated that it was going to do the balancing test and then
Can
failed
I
to do
stop you
that
for
when
just
you.
a second? Because I want to make
Yes,
sure
of
we're
course.
using the same language here. You called it 404B. It's actually the statutory admission now for other acts evidence, but I think what you're talking about is the 403 balancing test, right? The
Yes, that is correct.
proportionality
Which,
versus universal
yes.
effect. That's fine.
You're
Thank you. Go ahead.
absolutely correct. Yes. And for that, the court has to still do the balancing test to determine whether it's more probative than prejudicial. And in this particular case, for other reasons that were stated in the brief, I believe in addition to the court not doing it, it's not harmless error because, that it was clearly more prejudicial than probative. And also, the acts really, I guess the main reason I'm saying that is twofold. One, I don't think the acts really were very similar in nature. They involved, entirely different, I want to say age groups of children. And also there was a failure, which goes to one of the other arguments to impeach the witness who was the statutory other acts witness, which just aggravated that particular error. Um, which is part of one of the other arguments that trial counsel failed entirely to impeach that witness with other evidence that was available. I know there's a pretty extensive record of that as well, of these failures and what the evidence would have been. That is part of the third argument, I guess. So I'll move on to that.
Okay.
That we believe that Mr. Byers, well, and they all kind of intertwine, and so I apologize for kind of being all over the place because
That's fine.
it's a fact-heavy record, but we have to separate out the issues, I suppose. It brings me to the third issue, which I just wanted to touch on briefly. The trial attorney, what they did not do was that there was a failure to impeach the witness, which was the other act's witness, both with recorded statements from the forensic interview, which there were so many issues with getting the actual interview, but I think nobody was disputing the fact that in that interview she disclosed no penetration. As a matter of fact, her statement based on the transcript was that there was no penetration and that it was, and basically, and I don't know how to else quantify that, but some kind of situation where there was, I guess maybe the best way to say it is humping. But she was very clear in that interview that there was absolutely no penetration, which of course in a he said, she said type of case, that's very important. He also, failed failed to object to the testimony about his prior criminal history, which that testimony was twofold too. There was one witness that testified that she had looked him up on Otis, which is where offenders are listed. There was several people testifying about knowing him from prison, which, I do understand the argument that, well, it's really harmless because we all knew he had another conviction because that conviction was admitted. However, to talk about someone's criminal record, I think and criminal history, the case law is really supportive of that in terms of the jury should not be able to hear those things, and that it's so prejudicial that there's really no way to fix it other than giving someone a new trial. And I think especially in a case, again, where it was, there was no really physical evidence. It was a very delayed disclosure. And again, it was, a he said, she said type of situation. Mr. Byers obviously testified at trial in support of his innocence claim. So we do, and then there was the issue too, which was in regards to the psychological report. I'll rest on my brief on that one. I think that was
Yeah.
pretty clearly briefed. So, but with all of it, we are asking that you grant Mr. Byers' appeal and order him a new trial. And then I
Thank
would
you.
reserve whatever time for rebuttal.
Sure, you have plenty of time for rebuttal. Thank you very much. Counsel?
Good morning, may it please the court. Assistant Attorney General Brent Morton on behalf of Alpena County.
Morning.
Morning. I'll just respond to a couple of the comments and then be happy to answer any questions, or if you have a question, you'll interrupt and that's great. With regard to BG's testimony, the 768.27A
Yep.
witness, under the Watkins factor for dissimilarity, the sexual act and even the gender of the victim doesn't have to be the same. It's just taking all the facts together. And what there's a striking similarity here is the defendant in both instances used the same means to create a relationship and have the opportunity to abuse the victim. So I think that.
Well, just to be clear about this, as I understand it, the victim on the offensive conviction here was very young at the time it happened.
Yes, I think under 6.
Yeah, the other acts witness was 15 at the time, wasn't she?
Yes, she's a
And
teenager.
there was a fair bit of consent involved in it. I don't mean to suggest a 15-year-old can consent, but it was quite
It
different.
was voluntary.
Yeah, right,
And-
right.
And I think that plays into the MRE 403 analysis because it was not substantially more prejudicial. It wasn't gonna, because
Right.
the other act's victim was older, was voluntary. You could look at the similarities of, hey, call him Uncle Jimmy, this is a friend of my dad.
Right.
And building that relationship, and he had more opportunity to groom her. But I don't think it would impassion the jury to go, well, I'm gonna find him guilty despite not thinking that he's guilty of this offense.
Right. Can we talk just a minute about the 403 balancing? Because I don't fault the trial judge. It was a tough spot to be in because there was no determination made before trial, but the issue had been discussed. And then when it came up during trial, the judge, trying to refresh memory, said, have I ruled on this or not? I know I've heard it. And everybody assured the judge, yeah, you've taken care of it. And he said, okay, well, let's go then. But in fact, he hadn't. He'd never done the balancing.
Well, and of course, you're tied to the record. Maybe they did in chambers. Unfortunately, there's a lot of things
Right,
that aren't
but there's
recorded,
no record
But yeah, absolutely.
ever of 403 balancing.
But you have the parties going, oh, you dealt with
Right,
this.
right.
So you have a waiver in a sense,
Right.
on both sides. But I think that's why we can look now and go, well, let's do the balancing act. What would have it been? It's really harmless error that the balancing act didn't occur on the record. Because from our position, it was not substantially more prejudicial and probative under the Watkins factors.
Okay, go ahead. Sorry.
Oh, no, that's great. The other thing I wanted to talk about was the ineffective assistance of counsel with regard to not having the forensic interview introduced. The jury was well informed and knew it was a delayed disclosure. They knew there were inconsistencies. So again, I'm arguing that's harmless. It's not really going to impact anything. They know that. That wouldn't have helped. With regard to the statements about the defendant having been in prison, of course,
Yeah,
the defense counsel
Right.
said that he was convicted of sexual offense.
Right. I mean, the problem, you should never mention that somebody's in prison if you don't have to, but here it just seems so intertwined with everything that happened in the case. I mean, everybody seemed to know each other from prison.
Well, and when you break down, there's three instances, three witnesses who commented on it. The first one referenced Otis.
Right.
Which the judge found as a really a finding of fact that, well, that's not generally known in the population.
What Otis means.
The next issue wasn't in response to a question because, they'd ask, do you know him? And she said, not very well. And the prosecutor repeated, not very well. And then she said, well, as a friend of my dad's in prison.
Right.
So that was, that's not that's not something that should require a overturning. The detective shouldn't have said in prison. He should have said, the victim, AK, told me he was a friend of his dad and
Right.
stopped there. But that's an isolated case, and under an ineffective claim, I think a lot of trial attorneys are going to go, I don't want to draw attention to that. I've already done enough with that. So I don't see that should be overturned on that. And of course, the second issue, the hearsay issue, it's a wonderful rule that has befuddled us from the first day and continues to befuddle the bar and bench. So I hope I explained my position well on that, but I'm happy to answer any questions.
Okay,
Thank
thank
you
you
so
very
much.
much. Okay, you have time for rebuttal, plenty of time for
Yes,
rebuttal.
just ever so briefly. I just want to touch on two things. So, child, I guess, sex abuse cases are very, very difficult. And we know that they're probably some of the most difficult cases to try, especially when it's a he said, she said type of situation, which this was. So to kind of, I guess, imply that, it's not a big deal if we don't make balancing tests, if we don't, and that the things don't have to be similar. The two were so different, and there were, quite frankly, a lot of issues with the other ex-witness and her credibility, and that there was never brought up, it was never balanced, it was never, looked at. So I don't think, for those reasons, I think in this particular case, it's a serious error, just because of the facts of the case. The older child was presented, as a pretty credible witness. And I think, the general population, if we're talking about that, when they see these types of situations, it's things that they never thought about before. And I think they're probably pretty horrified by it. So when you have testimony from several witnesses indicating that this defendant, had committed child, sex assault, I think it's highly prejudicial in itself. Of course, the legislature had decided that, these cases are special and we basically need to let anything in. But we still have to do the very important job on making sure that, those other facts that come in are both, reliable, credible, and that we've done that balancing test. So I think to say, oh, it's not a big deal, and this court can just kind of look at it and hold it's not harmless, I think that would be error. The other thing that I wanted to just touch on is what the prosecutor is saying again, basically presenting it to this panel as it's not a big deal, mentioning his prior criminal history. One
Well,
of the
I don't
testimonies
think-
that were
I don't think-
elicited was
Hold on,
I
hold on.
apologize.
Sorry,
Just
I don't think his criminal history came in. What came in was the fact that he was in prison. And that came in several times. It was odd.
agreed. Which then lends to people to know that, he'd been in trouble before, which they're not supposed to know, other than, of course, there was, his prior actual conviction came in. But, the insinuation is that this man, the jury is left thinking that perhaps he has a lengthy criminal history that would have led him in prison, or that he has other priors, or that and that's significant. And I think it's even more significant because it was one of them, as the prosecutor just pointed out for the panel, was elicited by the detective, who's 100% should have known better. And
Yeah.
the other, instance from the one witness that was elicited, this is just my opinion, by the prosecutor. The prosecutor followed up on that. The prosecutor elicited that particular answer, and that should have never happened either. And I think the case law, to hold that it's harmless, again, I think it would be error. I think the case law is actually really defendant friendly on this. And I think the circumstances here, this was not just, one time that it was mentioned, it was 3 separate times, and it should have never happened. So I think, based on that record, it's not, just one instance of, a fleeting moment of mentioning it. That happened more than once by more than one witness. So I'm asking that he be reversed based on that as well. And with that, I thank you.
Thank you very much, Ms. Quirindongo. Thank you, Mr. Morton. Unless anybody has any other questions, that case will be submitted.
Thank you very much.
Thank you. Moving on to the next case, we've had a bit of a change. This is case number 18, docket number 369614, the People versus Dustin Ross Anderson. I've been handed a note indicating that Mr. Cicciotti will not be able to attend via Zoom today. And as a result of that, Mr. Gentry, you are the one and only here today. And so we'll give you 15 minutes and you should feel free to say whatever you like. I can't remember whether you were authorized to appear for argument and you've preserved or whether you're here.
Argument in
standing
this
for
one
questions.
and questions in 2 others, Your Honor. It's a long day for me.
Okay. Yeah, sorry. I can't remember which one was which. I remember your name coming up with standing for questions, but you have full-blown argument here.
Yes, this is a full-blown argument and I certainly won't take 15 minutes.
Okay, thank you very much.
Your Honor, it would take about 1.5 minutes to drive through the village of Pinckney. It's 1.67 square miles of low speed limits and stop signs. And Officer Prater, following the defendant, having a hunch, he had a hunch, because he had seen him an hour and change ago,
But it 45 minutes to an hour.
45 minutes to an hour.
Right, right. I mean,
Exactly.
the trial court said an hour and a half and there's nothing.
No,
on the
there's not an
record
hour
to
and a half.
support that.
45 minutes to an hour. We don't know why Officer Prater didn't know that since he has video in his car, but he didn't. So an hour is a drink. He could have had a drink and not. He had a definite hunch. But instead of waiting for a speed limit or some traffic violation, he followed him for a little while and got bored with it and stopped him on a hunch. You can't do that.
Well, reasonable suspicion is a very low standard.
It is a low standard. It's lower than probable cause.
Right, and just to be clear about that, there was some confusion about probable cause, but at this point, I think the case turns on whether there was reasonable suspicion to make the stop, right?
I agree with you, Your Honor.
Okay, good. So we're not talking about probable cause.
No, we're definitely not talking about probable cause there. The counsels below muddied up things with that, but it's reasonable suspicion. It's a Terry stop. Does he have that?
My understanding is that the officer testified about an erratic turn. But if you look, and I'm sorry, he didn't use the word erratic. It was like a
Sharp.
sharp turn. It is the officer testifying about the turn that occurred before he pulled your client over.
I believe so, Your Honor.
Okay, and that turn, put differently, is the officer describing the turn that's captured on dash cam as the sharp turn?
The turn that Judge Bain found to be legal and flipped and had the
Correct.
blinker on, that is correct,
Because
Your Honor.
that's my concern here is,
That's
okay,
correct.
reasonable suspicion is a low bar. So let's say we have the prior drinking 45 minutes to an hour before. And if there is an erratic turn, then that's different because then you have a reason for a traffic stop. But what I saw on video was driving the speed limit, putting a turn signal on, completing the turn, and then the lights going on and immediately pulling over.
That's exactly what I saw, Your Honor.
So what, and you're going to have to help me out. There were some cases sort of recently about because we review this de novo, but what do we do about the fact that the lower court may have determined from this video evidence that the officer testimony was not credible? Put differently, though we review this de novo, what do we do with the lower court's credibility determinations? Do we make it again on our own? There was a case about this recently and I'm sort of blanking on it.
I'm trying to remember that, Your Honor, and I don't know that case. I don't know that if it was published or not. I apologize. I do know that any factual finding of the court under Farrow is reviewed for clear error. So it's a higher standard than the novel. Certainly, Your Honors had the ability to look at everything yourself, but if the trial court found this was a legal turn, to find it was an illegal turn would have to be a clear error standard. And again, Your Honors obviously have the video in front of you.
Right. I think findings of fact are subject to clearly erroneous review.
Agreed.
But the ultimate determination about whether everything adds up to reasonable suspicion is reviewed de novo, right?
That is correct, Your Honor. And I do think we've got a lot of case law, not to Jen's question, because I'm not familiar with that case and I apologize.
No, it's
But
okay. I'm not either.
There's
so.
plenty of case law that, as Your Honors well know, the trial court is in the best position to determine credibility and watch the officer testify in this case. Judge Bain heard the officer describe this turn as something awful, watched the video and said, as Judge Jun said, it's a legal turn with a blinker. So I think that that's really where Officer Prater failed here, is he failed, one, in not just waiting for a traffic violation, because it's almost impossible to drive through Pinckney without committing one. I'm not kidding, Your Honor. I used to own a restaurant right outside of Pinckney. And as a result, all Officer Prater had to do was wait. Not only that, Officer Prater failed to convince Judge Bain when he planted his flag on that traffic stop. He failed to convince Judge Bain when Judge Bain watched the video. And two appellate courts up, Your Honor, I don't think that is the place. Yes, it's a de novo review, but I don't think that's the place to upset what Judge Bain saw on the video versus what Judge Bain saw on the stand. Thank you, Your Honors.
Thank you very much. That case will be submitted. Moving on to case number 19, docket number 375281. This is the matter of Marcin Wolski against Lauren Cartwright. And here I believe that we have somebody for the appellee who may appear to answer questions. Mr. Gentry, you are here to answer questions. So we'll turn the lectern over now to the attorney for the appellant, and good morning.
Thank you. Good morning. Julia Black on behalf of the appellant, Mr. Wolski. The briefs were pretty concise in this matter because I think there's only so much to say. I think this, I'm sure you read it, so I'm just going to cut right to the chase. I think that this case is very similar to the unpublished case of Ahola versus Burnett, due to the fact that Mr. Wolski genuinely thought that due to the fact there was a 4-year gap between when Miss Cartwright told him that she was in the process of getting a divorce to when the child was conceived, that she was actually divorced. Not only did these people engage in a 4-year relationship, her children would spend the night at his house. Clearly not something that you would think would happen if the parties were married. If the appellees were married. The parties held themselves out to be girlfriend and boyfriend. She indicated she had no other relationship with Mr. Cartwright. And by the time that the child was conceived in this matter, Mr. Wolski thought that the parties were divorced. Clearly with the statute, he meets the subsections 2, 3, and 4.
Sure.
I mean,
Right.
it's really just subsection 1. And I understand, there are different cases that, the Grimes case, for example, I understand. And I think it's distinguishable only because the time frame, the Wolski relationship with Ms. Cartwright was a long-term relationship, which
You don't dispute that when they first met, she made it clear to him that she was married.
I don't dispute that.
So did she say anything over the course of their relationship to indicate that there was some finality to this plan to get divorced?
She said she was getting divorced and that she didn't want to talk about it. Then at one point, she indicated, and it's in the affidavits, that she didn't want, that basically she had nothing else to do with Mr. Cartwright. Which led Mr. Wolski to believe that they were divorced. The fact that they announced in a family gathering that they were making plans for marriage, unless she was planning to commit bigamy and, violate the law, you'd have every reason to believe if somebody's planning to marry him, moved baby furniture into his home, that she was divorced. Mr. Walski was shocked to find out she was not divorced, and thus this case. I
It was an
also,
assumption on his part. She never told him my
She-
divorce is.
I can't stand before the court and say she absolutely said my divorce papers were finalized. He didn't assume that she was getting divorced because she said, I am in the process of getting a divorce. Did she ever say it was finalized? No, she did not. But they continued basically a 5-year relationship. And after she said she was getting divorced, her children started spending the night at his home. She was spending the night at his home. They announced that they thought they were getting married. I also think, and the court's well aware, under the Seraphin case, that it's a rebuttable presumption. This marriage is that the Cartwrights have, and I think there's an argument to be made that, it is an open, non-traditional marriage. So they're standing behind the fact that they want the benefit of the law to protect their marriage, but they took the risk. It's come out that both of the Cartwrights were involved with other people.
But
The
isn't
other,
that an argument for the legislature? There's nothing in the statute that says.
there
we
isn't anything, except that it's a rebuttable presumption. I don't know if it's necessarily an argument for the legislature, and I understand that that's the argument that's being made by the appellees. But I do think that the fact that it is a rebuttable presumption, that this fact pattern, I think, allows you to make that decision as well. The fact that, and we quoted from quite a bit from different affidavits, there were, I think, 4 affidavits that were signed by various people, all thinking that Ms. Cartwright was divorced. I think that he meets the criteria. We're in a situation where we've got all kinds of testimony where she's saying, here are the medical bills, here's what you're going to owe, he's a 99.9%,
Oh, yeah,
the
he's the
father.
biological father.
So-
I mean, he has actually been completely closed out of the child's life now, right?
Completely. Although I do believe that maybe the appellees are getting divorced. Right now, he's completely out of the child's life. He filed the action basically immediately, obviously well before the 3 years. The child's only 2 right now, and he's been completely out of the child's life. And it's a very unfortunate situation, but I do think that Ahola versus Burnett, although unpublished, I think is pretty analogous to this situation. The difference is there wasn't I don't have the smoking gun to say, here are my divorce papers. But yeah, I don't think you need that. And in Ahola, they didn't have that either. And in this case, as I indicated, the sheer length of the relationship and her saying, okay, well, Mr. Cartwright's completely gone out of my life. My client, albeit whether he should have or not, thought, well, she said she's getting divorced. He's completely gone. We're getting married. She's divorced.
Where does that completely gone language come from? I'm not seeing it in the
There
affidavit
was-
unless I'm missing it.
We quoted from, she said he's no longer a part of her life. 1 minute.
If you can't find it now, you can come back on rebuttal. You will.
That's true.
For rebuttal.
Um,
But I do think that's important.
yes,
So don't feel like you have to spend 5 minutes trying to find it now.
I'll look while he is arguing, because there was a quote that we had where she said, Mr. Cartwright is.
Where
complete-
he alleges she said that?
Yes, he alleges, obviously.
Okay.
He alleges. I'm not saying she said that, but yes.
So
he
she denies speaking this forthrightly about the end of her marriage.
She does, although there are 4 affidavits to the contrary about her at family functions and things like that. So I can find where he indicates that to her. But yes, I do believe that that's part of it. If there are no other questions, I can look
Right.
for that and.
We'll give you
then-
time to find it.
Okay.
It's much easier to find things when you're sitting at table.
That's
than
true.
when we're all looking at you.
No problem. Okay, thank you.
Thank you. Mr. Gentry, now you're standing for questions, but I
Yes, I have
suspect
the
we may
questions,
have
Your
a
Honors.
few. Let's assume that the statement that Ms. Black just made is accurate and it's in the record. Why isn't that enough for him to reasonably assume that she is no longer married?
Yeah, I don't think that quite the statement as Judge Boomster quoted and as counsel was quoting is in the record. But even if it is, the fact that he's out of my life doesn't mean that they're not married. I mean, there are people who are marriages is a lot of different things, and our legislature said marriage as opposed to defining it. And it's very dangerous for this court to give a definition to something the legislature didn't.
No, I mean, I think to the extent that the argument's made that an open marriage is not a marriage, we reject that out of hand and we have to.
Mhm.
But this is a slightly different argument because there's no doubt if she had come forward, presented him with falsified divorce records and everything had unfolded as it did,
Agreed.
there's no question that he would have
And
a legal right to this child.
agreed. Agreed. Candor to your court, your honors. I did actually, because I said in my brief, looked at Court Explorer to figure out if there was ever a divorce case between the parties. The parties filed for divorce in September of this year, your honors. So I'm just candor to the court. I wanted to bring that to the court's attention because it was brought up. I did have
So
knowledge
it's
of that.
pending now, but they are.
It is
still
pending.
They're still legally married.
They're still legally married, and it was only filed after the briefs in this case. So, thank you, your honors.
Thank you, Mr. Gentry. Okay, take a moment. I mean, technically, you have a lot of time left for rebuttal, but please don't sit there for 20 minutes trying to find it. I'll tell you what, we have access to the record. We will do our best to find it, I promise. Okay? Okay, if you want to do that, that's fine. That case will be submitted. Let's move on then to case number 20, docket number 372134, the Auburn Area Chamber of Commerce against Tracy Arthur. And we have all sorts of attorneys listed on this case, so I'm not sure who's coming forward to argue, but
Your Honor, I believe that Mr. Patterson is going to be arguing. He's just walking in the door. Right
there we go. Okay, that's fine. Just a moment. Let's give everybody a chance to get seated and then we'll get started with the argument. Okay, on behalf of the appellant.
Morning, Your Honors, and may it please the court, Mitchell Piper on behalf of the appellants in this case. The issues in this case are relatively straightforward. This was a motion for summary disposition that was brought by the defendants before the trial court on the basis of MCR 2.116C8. Their allegations were that the plaintiff in that case failed to state a claim on which relief can be granted. And as this court is no doubt aware, the standard for that motion is on the pleadings alone, and the well-pled allegations must be treated as true. The particular allegation at issue here is that Robert's Rules of Order basically acted as a gap filler where the Constitution and bylaws of the Auburn Chamber of Commerce didn't otherwise provide for those rules.
Well, stop for just a second, because I think this case is important insofar as it establishes the hierarchy of governing documents for any entity. So I think we have to agree, state law is supreme, right? If
That is correct.
something's in a statute, that governs.
That is correct.
Now, when you form a company, you can have bylaws. In an LLC, you can have an operating agreement. And I think we all agree that that takes precedence over Robert's rules, unless Robert's rules are expressly adopted, right?
I don't, it's not our position that Robert's rules need to be expressly referenced in the documents themselves. They could be the governing rules of the organization, and there could be a history of using those as the rules of the organization. Now,
Right, but here's where I get confused, because we have this meeting that takes place in a designated spot where everyone attends. During the course of the meeting, one of the dissidents, whatever you want to call these people who are unhappy with the leadership, stands up, tries to make a motion, is not recognized, nothing happens. Now, under your telling of it, the meeting's never formally adjourned, and so it continues in this park, right?
that's correct.
And then I think the way you explain it is that when these disgruntled members get together to continue the meeting as you would have it, they do a few things. And one of the things they do first is they make a motion and then it passes to follow Robert's Rules of Order, right?
I think there's an important distinction there. They make a motion to formally adopt Robert's rules.
I got it. But the first time that anybody formally acting on behalf of the organization adopts Robert's rules, it's at that meeting in the park, right?
I would acknowledge that yes, that's the first time there is a motion to formally adopt it. However, again, on a C8 motion at the trial court needs to accept the well-pled allegations. The well-pled allegations in this case were that Robert's rules were historically used.
I got it. Well, and if we get to Robert's rules, this is one of the biggest problems I have with your argument. You were given an opportunity again and again and again by Judge Sheeran to identify what in Robert's rules required the person who stood up and made the motion to be recognized. Could never find anything. Now, we've had months and months to try to figure out the answer to that question, and I can't see anything in the appellate brief that says what provision or provisions in Robert's rules say that the presiding officer at the meeting had to recognize the movement and to entertain the motion. I still can't find it.
Well, I think, Your Honor, that yes, that is correct. There was some discussion with counsel below at the hearing about whether or not he could identify a particular provision. That attorney could not identify a particular provision there. It's our position, however, that there were appropriate motions that could be made. For example, a motion under Robert's rules to remove the presiding officer. And given that this was a membership meeting, that motion had to be recognized.
Right, but here's the problem. Unless Robert's rules override the bylaws make it clear that the vacancies have to be filled in a particular way. You can't rely on general principles in Robert's rules to override the bylaws, can you?
But I don't think that there was a vacancy at that point in time. When the motion was made, it was a motion to remove the presiding officer. Until that presiding officer is removed, there's no vacancy. And then at that point in time, there's a vacancy. Robert's rules were formally adopted, and then they proceeded with the meeting in the park.
Right. But the way that they appointed themselves is directly contrary to what the bylaws allow.
I don't believe that is true, because at the point in time, I think it's important to step back from that, because there is a very particular line in the bylaw that says that the government of the organization is vested in the governing board, subject to the will of the membership. Subject to the will of the membership must mean something.
But it doesn't mean that you can fill a vacancy in a manner inconsistent with the bylaws.
I would agree that is true, but again, we're stepping back. This was a C8 motion that
I got it, but I mean, corporate governance has to be governed by rules, and we have to be able to understand what everybody has to follow. Otherwise, you have complete chaos. And under your reading of it, some sort of broad pronouncement of the sense of the group overriding the bylaws just sows the seeds of chaos.
This is a community organization, and I will acknowledge that the Constitution and bylaws themselves are probably not the most complete set of bylaws that I would have written, for example, if I was preparing this organization.
I get it. I get it. There are lots of LLCs that don't even have operating agreements, which
Correct.
is
Correct.
about as illogical as anything could ever
Correct.
be.
Correct.
But here, we do have a constitution, we do have bylaws, and however defective they may be, they govern over Robert's rules.
They do, but there is that language, again, subject to the will of the membership. This was a membership meeting as distinguished from a governing board meeting. Subject to the will of the membership must mean something. Mr. Gundin was able to make that motion because he is a member. There was no dispute that he's a member of the Chamber of Commerce. And so it would be our position that he was able to make that motion. He was not recognized, that the meeting was never formally adjourned, and that the historical use of the historical way that they controlled their meetings was under Robert's rules, and that must be given weight regardless of whether it was formally adopted or at what time it was formally.
Right, but chaos didn't ensue until this meeting in the park where your people tried to throw out the leadership and then replace them in a manner inconsistent with the bylaws. And that's when things really went off the rails. I mean, they quit claimed the property and they transferred the bank accounts. I mean, all of that, if you were here simply arguing that the motion should have been heard, okay, fine, we can go back and fix that. Put all those people back in charge and say, you have to hear the motion and you have to allow a vote on the motion. But
And why do you have to hear the motion?
Because Mr. Gundin is a member and this was a membership meeting. So the bylaws distinguish between two types of meetings where there's a governing board meeting, that would be the president, the vice president, secretary, et cetera, and a general monthly membership meeting. So given that Mr. Gundin was a member of the chamber, he should have been recognized because he had the right to participate in that meeting. So that's our position there. And Judge Yates, I recognize that and I think, quite frankly, my clients recognize that perhaps hindsight is 20/20 here. But again, those are factual questions that need to be addressed.
It's not a factual question that they installed themselves as leaders.
That's correct.
It's not a factual question what the bylaws require to fill a vacancy.
That's correct. They did vote to replace the governing board, and they did install themselves as leaders. They believed what they were doing was correct and authorized by both the Constitution, the bylaws, and the historic use of Robert's rules. If there are no further questions, I'll reserve my time.
Okay, thank you.
Thank you.
Piper, appreciate
Thank you.
it.
Thank you.
It's a fascinating case.
Thank you.
Mr. Patterson.
Good morning, Your Honors. Chris Patterson on behalf of the individual defendant appellees. It's always helpful to know, I think that Judge Yates, you and I see the case very similar, and I think also as it relates to the organization of our thoughts for purposes of this morning. I do think it's problematic for purposes of just the policy piece to allow chaos. If you scrutinize the facts that are set forth in the complaint itself, it really does demonstrate, if this were to be appropriate, to allow Robert's rules to be superimposed over not only the Nonprofit Corporation Act, but even the bylaws. You run the risk of lack of stability for thousands, if not millions of dollars in lots of nonprofits in the state of Michigan.
Plus, it violates the fundamental concept that an entity can govern itself as it sees fit. If they prescribe in bylaws or an operating agreement for an LLC what has to happen, then that's what's supposed to happen.
Yeah,
unless it violates Michigan law.
Absolutely agree, Your Honor. I think that the trial court was clear and affirmed in a few key pieces, and I want to break them apart just to kind of confirm them for the court this morning, but I'll do so much quicker understanding the court's understanding of the briefs. First, it's pretty clear in the piece that I think is missed in appellant's briefing. It was missed below, but I think it's missed above as well. It is just the chamber's bylaws and the Nonprofit Corporation Act that we should be looking at. And the trial court was right in the constant questioning of opposing counsel and when analyzing it on the record that if Robert's
Under those
rules.
same documents, should his motion have been heard?
I'm sorry.
Under those same documents, should opposing counsel's client's motion have been heard?
No, because if you first turn to the act, what's important is that in MCL 450-2406, there is no distinction between the meetings. It actually says in the statute, It'll look at both the board of directors meetings and member meetings, and the chairperson shall preside. So that's what the statute first tells us. So this sort of idea that there's a material distinction that could be corrected through a motion to amend makes no difference. So if the law controls, we look at the presiding officer. We go to the next subsection in the statute, and that section says that the presiding officer, whether at a member meeting or board of directors meeting, is going to get to determine the order of business and has the authority to establish the rules for conduct of the meeting. So as far as sending it back or his ability to make that motion, the answer is no under the statute. The statute's clear. The presiding officer, the president, gets to direct the order of business at the meeting.
So
Now-
the language directing the order of business includes deciding whether or not to hear a motion.
Yes, absolutely, Your Honor. But it actually gets even better because the Nonprofit Corporate Act, I think, further forecloses this argument because it does tell us, well, there are two other sources you could actually go look to see if this would be permitted. It says you could look at the articles, and I think brother counsel and I agree there's nothing in the articles germane to this exact issue on the motion. So we go to the bylaws. And the bylaws pretty much parrot to some extent the powers that are in the statute. The bylaws say that the president shall preside, and it does address both meeting types. It says at all regular meetings and governing board of directors meetings. So I disagree that it's not addressed in the statute. We disagree that it's not addressed in the bylaws. It goes on to then say, in addition to, remember I said in the statute, it says direct all order of before the meetings. The bylaws say to supervise the organization's affairs and activities. So it's further completed that through both the bylaws and the act, President Michael was entitled to supervise the affairs, direct the order of business.
Let me ask you a broader question. Let's say, as is done in any well-run organization, that you have a published agenda before the meeting. Everybody has the agenda. Somebody wants to take up something that's not on the agenda, and the presiding officer refuses to recognize the motion because it doesn't relate to something on the agenda. Now, you can handle that in one of two ways, I guess, because typically a reasonable agenda has new business and old business, and you can ask to bring it up under new business if you want. But let's say somebody's disgruntled and they want to make a point, and the presiding officer refuses to entertain any motion that's not germane to an agenda item. Is that acceptable under the act?
No, Your Honor, because I think what's important here is we have to remember that the bylaws themselves is the contractual arrangement that's endeavored in that organization between the members and the corporation. So then when you look at the bylaws, you have to consider, as you indicated, Judge Yates, that organization gets to determine its destiny. If you do look at the organizational section of the bylaws, it indicates power is vested in the board of directors. So it was their decision, the contractual arrangement that they determined between members and the organization to vest that power in the board of directors. When you then look at the actual running of the meetings, it's vesting that power in the president himself or herself at the time to conduct the meeting. So in this instance, no. And the other important piece is that whether it's a board of director meeting or a member meeting, the people who could be taking the vote on the agenda would be the board of directors, because in this organization, they've clearly vested the power in the board of directors. Now, this is very similar to lots of even public bodies in that there are certainly redress. We're not suggesting there's no redressability. What can't happen, certainly can't happen under the statute and the bylaws, is self-help and chaos. If you look at the Nonprofit Act, there are court remedies for which you could certainly take issue with a presiding chair that refuses to follow the bylaws. You certainly could also take derivative suits if you thought that the board as a whole was not carrying out the function of the corporation. But I mean, you have to really specifically look at the facts as alleged. To condone this would be to allow self-help and completely ignore the contract that exists between the members and the corporation. And there's a couple key pieces when you look at the bylaws that are pretty clear. And this is sort of goes very clearly into the allegations piece and whether or not the motion to amend was properly denied. What's very clear in the act, and when the act tells us to look at the bylaws, is that order of business at the meetings, supervision of those meetings, and then the replacement of officers, which I appreciate, Judge Yates, you recognize this morning, that is not a member decision, not as it relates to removing a presiding officer at a meeting. So if you look at the allegations, remember that The first allegation that's pled about the removal of the presiding officer, it's the presiding officer at the meeting. Well, there's no powers provided to the members in the bylaws for that. Later, they allege a motion to remove the president and vice president as director. And again, there is silence on that in the bylaws, so we have to go to the act. The bylaws do allow an annual election process. But as it relates to that point in time where they want to instill their own president pro temp, which by the way is not an office that's even defined in the bylaws, they would have to have that person in place to leave to the park to then, as their allegations carry out, legally do the rest of the actions, right? And I'm going to get to the Robert's Rules piece.
Right,
But
I mean, I think what they're trying to suggest here, and I know this is an absurd hypothetical, but it would be the same as somebody buying 50 shares of a publicly traded company, going to a meeting of the board of directors, trying to stand up and move that the board be removed, and then being upset when you weren't allowed to proceed on that motion. You made a good point, because there's an annual meeting once a year. And if you're unhappy with the governance of the corporation, that's when you can make your motion and try to get rid of people.
Well, and I want to use your hypothetical, Judge Yates, to just make this point clear. It's possible that if you looked at those bylaws for that public corporation, they could put in there some rights for a shareholder with X amount of shares, and they could have adopted Robert's Rules as parliamentary procedure.
Absolutely.
The part that they're attempting to sort of foist as part of Michigan's law is that somehow Robert's Rules is a gap filler if there's silence. That's not the case. The Nonprofit Corporate Act looks at the bylaws and it looks at the articles. You won't find anywhere in there reference to Robert's Rules. Instead, the members decided to agree with putting this power in the president. And as we identified, they could always change those board of directors through the annual election process.
Right. And there's one shot a year to do that.
Yes, correct.
It's not open for debate at every meeting.
Correct. Well, and to your point, Your Honor, I think to the extent that at a single meeting, the presiding officer were removed, the bylaws is clear on that point, which is that the board of directors gets to appoint the replacement for the successor of that fixed term. Meaning that hypothetically, if you were to remove the president, the vice president per the bylaws automatically assumes those powers, not an official's office called president pro temp. In addition to that, if the vice president under the bylaws was unable to fill the capacity of the president, that is not an appointment power of the members. During the term, the successor is appointed by the board. So there's no way under the bylaws for which Robert's Rules really become relevant. Now, when you look at the trial court's review of the complaint, I just want to note one thing that we heard this morning. What we kept hearing was that the trial court was responsible for treating as true the well-pled allegations. And there's a missing word there. The word there is extremely important. It's well-pled factual allegations. And this is where, when you look at the trial court's review, there's only 2 allegations in the complaint even related to Robert's Rules, okay? There's allegation 16 that just boldly says, conclusory, Robert's Rules govern the board meetings. That's a legal conclusion. The court was able to reject that under this court's precedent and the Supreme Court's precedent. So yes, we agree that well-pled factual allegations can be taken as true, but that doesn't change the outcome. What's interesting that the judge noted is that in allegation 59, that would only be accepting as true, as was noted here this morning, that they were formally adopted actually after the motions for which would have instilled individual appellees. We did address this in the brief, but I think I'll just sort of direct to the court. There is a case that's on all fours to some extent as to how Robert's Rules, if not listed in the bylaws, is immaterial and irrelevant, and that's in Tarver. It's certainly unpublished, but I think if this panel were to accept it, it leads to one conclusion, which is essentially if the bylaw sections don't reference Robert's Rules, you can't state a claim for relief based on that. That case, granted, unpublished, but I think on all fours with respect to the fact that the trial court was correct as it relates to the dismissal. Now, I do appreciate the court's comments that really, as it relates to any argument to amend, we don't even fully have that set forth in the briefing on appeal, let alone the record below. I've already addressed the position that somehow an amendment related to a difference between director and member meetings is a red herring. There's no distinction, and the bylaws already address that. Now, there was comments related to an allegation about using Robert's rules through custom that was raised. I want to discuss that, and then also actually identifying specific Robert's rules provisions. What's interesting for the trial court below, and what wasn't addressed this morning, is that there actually wasn't any written amendment proposed, so we don't actually know the allegations. All they were was described on the record below, and they're addressed in the argument above. It's pretty clear that 2116 I-5 and 2118 would require a written amendment to be proposed, and this court has affirmed a trial court for dismissal on an unwillingness to allow leave to amend based on not providing that amendment in writing. So I think because we're actually talking about, once we get to the right to amend an abuse of discretion standard, it certainly would be in this court's prerogative to affirm the trial court. The one comment I want to make, just as it relates to Robert's rules as controlling by custom, there's no implication or reference of historical practice in the Nonprofit Corporate Act. And there's nothing that's cited in the appellate brief that suggests that you can actually, by historic practice, waive those bylaws and then have those parliamentary procedures trump or be superior to the statute. But there's even a more interesting part, and maybe this is why we haven't seen actually any stated allegations. If you look at Robert's rules itself, and this is in section 225 of those rules, it even acknowledges the ability in Robert's rules to have Robert's rules apply by custom. But what it says in Robert's rules is on point with our position. It indicates that custom can be adhered to, but only to the extent it's not contrary to the written rules of the organization. So Robert's rules, for which they would like to amend, even indicates the written bylaws will always trump Robert's rules, particularly if you want to go back and allege it's only based on custom. I won't sort of get into the individual pieces about Robert's rules and the rule. There's 3 rules referenced in the brief, unless the court would like me. The one thing that I think is just really interesting about the trial court, I know that there are some decisions decided by some of you on the panel, really sort of asking trial courts that when there is a request made to amend, to make sure they do a good job at looking at compliance with I-5 and 2118. And I think you see that in the transcript here. There was an effort made by the trial court to give the opposing counsel an opportunity to identify what factual event or source of authority would suggest that Robert's rules could ever be superior to the bylaws.
But you concede that you have to allow leave to amend unless amendment would be futile. I mean, there are other factors, but they don't come into play, delay like that or something. But ultimately, it's a futility standard, right?
Correct. So the judge is clearly on the record not applying a higher evidentiary standard. The judge is trying to understand, since no written amendment was provided, what factual event would suggest that the bylaws are now trumped or have been amended by Robert's rules? And nothing's identified below. And honestly, nothing's identified in the appellate briefing above.
Right. That's what concerned me the most, that they had months to come up with some provisions of Robert's rules that they could show would produce a different outcome. Still nothing.
Yeah, Your Honor, 7 months from the filing of the complaint to when we argued it in front of the circuit court. And at that time, still nothing's identified. So I really appreciate the court's questions and comments. I think the trial court was clear and appropriate, not only in the dismissal, but in addressing the appropriate standard for determining whether or not an amendment would be futile. That's also addressed in the trial court's final order, where they did so under both I-5 and 2118. So we certainly would ask that this court affirm the decision of the circuit court on both issues, to grant the dismissal, and also certainly no remand would be appropriate. There was no abuse of discretion in denying the amendment to the complaint. If you have any questions, I'm happy to address them. Thank you.
Thank you. Mr. Piper, you have some time for rebuttal if you like.
Thank you.
Thank you so much.
I will be just very brief. They did reference the Tarver case, the unpublished case. There is a footnote in that case that indicates that Robert's rules were not referenced in those briefs, but there's nothing in that case that says that that has a bearing on this case. Again, there's a lot of use of the word trumping the bylaws. It's our position that the historical use of Robert's rules was not to trump the bylaws, but to supplement the bylaws.
They're interstitial. They fill the gap.
Correct. That's correct. And that would be appropriate here. I think the one last thought that I will leave the court with is, there's been a lot of discussion of the facts of this case in terms of there being chaos or dissidents or people who are, these people all, regardless of the side, care about the Chamber of Commerce and thought that they were doing well. Bad facts make bad law. The reality here is that this was a motion on MCR 2.116C8. The well-pled factual allegations must be accepted as true. The trial court did not do that. We'd ask this court to reverse.
Thank you very much.
Thank you.
Thank you. Well, thank you both. Fascinating case. It will be submitted. We have now come to the end of our 10 o'clock call, so we're going to take a brief break and we'll be back to pick up the 11 o'clock cases in a few minutes. Thank you very much.
Honorable Court of Appeals for the State of Michigan is now in session. Please be seated.
Thank you very much. Welcome back. Thank you for your patience. We'll pick up now with the 11 o'clock call. Case number 21, docket number 368368. Christopher Collinger against Miller Broach Inc. And I'm sorry if I mispronounced Mr. Collinger or Collinger's name. It's too consolidated. Oh, I'm sorry. Thank you very much. And there are other consolidated cases that I have to announce as well. And I should have known that. Also docket number 368543, Marvin Washington against Euclid Industries, Inc. And a third case, docket number 368704, David Bellamy Jr. against Sundance Beverage Company. And I'm sorry that that slipped my mind. I should have known that one because I read all about this. When you're ready, you may begin.
Good morning, Your Honors. John Gehring, Assistant Attorney General on behalf of Appellee Michigan Unemployment Insurance Agency. I will endeavor to keep my comments brief. I'll reserve any remaining time for rebuttal. Under the Michigan Employment Security Act and federal regulations, the confidentiality of unemployment compensation information is not encouraged. It is mandatory. The circumstances in which unemployment compensation information can be produced are exceptions. And in our view, that's really the crux of this case. The stated view of the Appellate Commission that confidentiality is just encouraged, sort of an aspirational goal to strive for rather than a requirement subject to narrow exceptions, is what we believe is the foundational error that led the Appellate Commission to the erroneous conclusion that any employer to workers' compensation case falls under the statutory definition of interested party.
How much, if any, deference do we have to give to the agency's determination? Because they took a pretty consistent position all the way through the process, and their final position, of course, is that you're wrong and the other side's right, and there's not an absolute requirement of confidentiality, and so they get the records.
Yeah, it's respectful consideration is the standard. I think
Nothing like Chevron deference.
No. Certainly, I would love that, but that's not the case. Respectful consideration.
All right,
is the
so we'll be
standard that we have
respectful
here.
this morning.
All right, thank you, Your Honor. I appreciate that. And even if the court, despite that respectful consideration, agrees that all employers are interested parties, it's the sort of same view that confidentiality is just encouraged that led the Appellate Commission to erroneously conclude that the basic strictures of civil discovery don't apply, and employers can demand every scrap of paper relating to a workers' compensation plaintiff, no matter the topic, no matter how far removed in time from the workers' compensation case, because, well, you just never know what you might find.
Well, what role do the court rules play here? Because 2.305 on non-party discovery, it seems to me, generally authorizes non-party discovery, but it places some limits on it. Is your view that the rule is absolute and disclosure is never appropriate, or that instead there's a proportionality standard? How do you want us to look at this?
Well, sort of in the event that the court disagrees with our position on who
Right,
exactly
it's
is
a
an
hard
interested.
no in the first place, but you
Yeah.
have an alternative position.
In the alternative, we think the basic structure of civil discovery, we don't think, certainly in the face of the overarching concern in section 11 on confidentiality, we don't think use of the word might somehow transforms, this to something outside of civil discovery, and it's just go crazy, no limits, ask for anything. Because certainly for any given individual, the agency may have records that go back a long way. And certainly I won't get into the details because there is confidentiality, but for one of the plaintiffs involved in these consolidated cases, there are records that go back almost 15 years before the workers' compensation case. And there's just no plausible argument that this is sort of proportional to the needs of the case or is sort of reasonably calculated to discover admissible evidence to ask for things that far back.
Those are two very different standards, because when you talk about whether it could lead to discoverable evidence, that's the old rule. The old rule
Yeah.
now has gloss on it. The gloss on it is proportionality, which you just described. So
Yeah.
those two are certainly not synonymous.
Yeah, I wouldn't dispute that, Your Honor. And to the extent the old rule came out of my mouth out of force of habit, I apologize. But
Old habits die hard.
That's true. That's very true. Certainly we don't find that to be proportional. And, I think it's worth noting that even if a workers' compensation plaintiff has literally never applied for unemployment benefits in their entire life, the Unemployment Insurance Agency gets quarterly wage reports from every employer in this state every quarter that lists all of their employees, all of their social security numbers, and the wages they paid for that quarter. The agency has records that go back to 2012, quarterly wage reports. And so even if someone has never applied for unemployment benefits, if we get a workers' compensation defendant subpoena that says any and all records, there's very likely going to be wage records going back possibly to 2012.
Right, they don't relate to any claim.
Yeah, and what, it's disproportionate. What possible relevance is there to what wages someone made in 2012? It's just not there. So the subpoenas themselves, the specific subpoenas themselves, any and all records, is just, in our view, just a wild overreach. There needs to be, if there's going to be discoveries, some specific limits, some give us things that actually could be relevant. And then if the agency has them, they can produce them. There should be some sort of time limit. We've proposed, documents before the date of injury, very unlikely to have any relevance. In our view, what's proportional is from the date of injury forward, sort of similar to the unreported Packard case that we cited to.
But proportionality is really a case-by-case standard.
I agree, Your
You
Honor.
can't come up with governing rules that apply across all requests.
I would, in general, agree with that, Your Honor. I think I think there can and should be a general rule that any and all is well past wherever that line may happen to be in any specific case. And this is, it's no small matter to the agency. Thus far this year, the agency has received roughly 1,500 workers' compensation subpoenas from workers' compensation defendants. And the agency cannot use federal dollars that are over 95% of its budget to respond to those.
Well, sounds like a FOIA problem. What's that? Almost sounds like a FOIA problem. Get swamped with FOIA requests if you're a public entity. Yeah, and certainly Section 11 has a great impact on FOIA requests. I believe lately, my understanding is that we have been getting some FOIA requests from workers' compensation defendants. Yep. But that's an issue for another day. Right. Back to sort of the initial topic, whether we kind of get to number 2 at all. Which is a hard and fast prohibition. Yeah. So under Section 11, 11B1, Roman numeral sub 1, information in the unemployment agency's possession that might affect a claim for workers' disability compensation must be available to interested parties as defined in Rule 421.201. And if the legislature had said information in the unemployment agency's possession that might affect a claim for workers' disability compensation must be available to interested parties to the workers' compensation case, well, we wouldn't be here. If the legislature had truly intended for its reference to Rule 201 to mean any party to a workers' compensation proceeding is an interested party, that's what the legislature would have said. But that's not what they said. They said interested parties as defined in Rule 421.201, and not the first sentence of Rule 4201 sub 1, all of Rule 201. And under that, the entirety of that rule, when it comes to employers under subsection 3, interested parties are limited to employers who have been or may be charged with benefits. And the employers here have never argued that they fall within that definition. Rule 201 begins with a general definition of interested parties as used in the act or these rules of anyone whose statutory rights or obligations could be impacted. The act at issue is the MES Act. And this context shows that the rights or obligations at issue are those under the MES Act and not other statutes. Rule 201 then sets forth the specific categories of interested parties whose rights and obligations under the MES Act might be affected. And under that entire rule with respect to employers, interested parties are those employers whose accounts have been or potentially will be charged. So, what does the rule allow? It allows employers involved in a disputed issue before the UIA to receive relevant documents in the workers' compensation case. For example, say there was a dispute on being able and available to work under the MES Act. How this would work, typically as a procedural matter, an employer will submit a protest to the agency. With that protest, they will submit any supporting documentation. The agency will then send a request for information to the claimant for benefits, saying this issue has arisen, asking some questions and asking them to respond. They can respond whether it's online or by mail. They answer the questions. They can provide any documentation that they want to provide. Then the agency issues a decision called a determination. And if no one disputes that determination, that's where it ends. And the employer is not going to have whatever the claimant submitted to the agency, and the claimant's not going to have whatever the employer submitted to the agency. And so that's what this sort of addresses. So our view is that here interpreting statutory rights or obligations in isolation to mean any statute, as the Appeals Commission did, ignores the context of the rule. And so it's kind of not really disputed here. The primary piece of information that's sought, the benefit payment history after the plaintiff's date of injury, can be obtained by discovery to the plaintiff. And there was sort of repeated connection in the briefing from the employers of the employer's rights and the claimant's rights. And our view is going to inhibit claimants as much as it inhibits the employers, and it's bad for everyone. And that's just kind of a red herring. Any claimant for unemployment benefits can log on to their account. They can see their benefit payment history.
They can see any determinations or redeterminations. They can see any correspondence that the agency has sent them. They don't need a subpoena at all. And again, we just believe these subpoenas are just on their face overbroad and not proportional to the needs of these cases to go back to 2010 or 2009 and, maybe there's something here we can use to attack their credibility. That just isn't how the process of discovery works. There has to be some tangible reason to think discovery is going to produce that sort of information. And again, we just don't have that here. So we respectfully request that the Appeals Commission be reversed in its entirety. And if not, we believe the subpoena should be quashed as overly broad and the records produced limited, and that employers should have to, like in any typical civil proceeding, when a subpoena is issued to a third party, pay the agency's reasonable costs of producing that information. Thank you very much.
Let me ask you one question before you
Yes.
sit down. So I think I heard you say in the course of the first prong of your argument that MCL 421.11B1I
Mhm.
sort of, I forget your exact language, but incorporates the totality of Rule 421.201.
Yes.
Which I think is how you get to your argument under subsection 3 about chargeable employers. And that
Correct.
sort of thing. I guess I want to probe that a little bit, I guess, because what subsection I of the statute says is that information must be available to interested parties as defined in Rule 421.201. So I guess I'm suggesting that maybe the entirety of Rule 421.201 isn't the definition of interested parties, but that the definition is contained within that rule. And then the rule contains other follow-up provisions, including subpart 3 that you're relying on, including a description of what the interested parties' rights are, that sort of thing. But I'm wondering if the definition, which is referred to in the statute, isn't really just the first sentence of the rule, which is the term interested party as used in the act or these rules means anyone whose statutory rights or obligations might be affected by the outcome or disposition of the determination, redetermination, or decision, period. That's the definition. And then the rest of the rule is follow-up to that, but isn't being expressly incorporated into the statute.
So
follow what I'm saying?
Yeah, I understand your question, Your Honor. And certainly our view is that you have to read the whole thing because in our view, the whole thing is about who is an interested party. It specifically in subsections 3 sets out some employers who are very explicitly not interested parties. And so in our view, the entire rule is about interested parties setting forth the universe and then specifically defining that universe in a way that's more limited. Thank you, Your Honor.
Thank you. You'll have time for vote. Thank you so much.
If it pleases the court, Randy MacArthur on behalf of appellees. Your Honors, if I could first deal with, I think, the disclosure issue. There was a reference to the onerousness of the production of records in response to the subpoenas issued by appellees. I would contend that there is a provision within the Workers' Compensation Act and the rules that are promulgated by the Workers' Compensation Agency. It's known as Rule 9.7. I referenced it in my brief. Rule 9.7 gives an entity that's been subpoenaed an option to go before the trial magistrate and request that records be reviewed in camera. If that occurs, if that's requested, the trial magistrate will assign another magistrate to review records in camera. And at that in-camera hearing, the review magistrate has the authority to hear arguments about the relevancy of certain records that are being produced and the confidentiality of those records being produced. In this way, the records from long ago, if UIA is correct that they're not relevant, those records could be precluded from going in and not provided.
But hold on just a second, because it seems to me that the evolving approach to discovery in Michigan is one of proportionality review. What you just described sounds to me like the old standard. Are you suggesting that there's a 2.305 type of review that the magistrate can undertake, a proportionality review? Because the problem with non-party subpoenas is that you're imposing costs and burden on somebody who's not participating in the litigation. And that's why the court rules were rewritten as they were a few years ago, to take some of that burden off non-parties because they're non-combatants. And you can't just externalize the cost of trying to get your hands on everything you want to see.
Sure. Well, the standard that the review magistrate would use would possibly be subject to the decisions that's going to be written by the court here. So I'll say that,
Okay.
number one. Number two, I would say that the court rules by statute, do not directly apply to the Workers' Compensation Agency. A magistrate could take those under advisement if UIA raises it, and could not necessarily require the production of all records in response to the subpoena, but could ask the UIA, well, what's the general category? Before you produce any records, what are the general categories of records that you have? And that review magistrate could then just make a proportionality decision, as you're suggesting, and
Could
say,
or must?
depending on the outcome of this
Right, here's the thing.
decision, they could be could. Yeah.
I can't speak for my colleagues here, but it seems to me that these subpoenas ought to be enforceable to some extent. So you get something, but I don't see why it would be the case that you get everything every time. That doesn't make any sense at all.
Yeah. A couple things, if I could respond to that, because it's a good and fair question. I want to make clear that statutory rights that work comp litigants have that are affected by the information the UIA has is not just the amount of UIA benefits that were paid to a claimant who now happens to be a work comp claimant. That's part of it, but the Workers' Comp Act also requires work comp magistrates and therefore the litigants to prove qualifications and training and work experience of that claimant, because that factors into a decision about disability. So a claimant's prior qualifications, their training, their prior work experience, all of which are within the records by the UAI, are relevant to a magistrate's decision and therefore the work comp litigants. So there is an extent to which some of those pre-date of injury records that the UIA have are relevant. How far back that goes, I would agree with you. I don't need records from 2001. Records from 2 or 3 or 4 years before would probably be sufficient. And I would say that that could all be considered by the review magistrate, and quite frankly, maybe self-regulating, because if there are going to be costs associated, I'm not going to pay $10,000 for records, right?
You hit the nail on the head, because that's the other problem, the externalizing costs problem, because it seems to me that the way that this generally works is we don't want to impose costs on non-parties for parties to litigation to conduct their discovery. And I presume the same operating principle should apply in the administrative context, right?
I would agree.
I mean, you can't just go out and demand everything from everybody and expect it won't cost you a penny. That's completely unrealistic.
We were involved in the GM litigation involving the foundries up in Saginaw, and I remember that some of those subpoenas, GM's response was, where do you want us to drop off these 3 semi-truckloads of records that are going to cost you X number of dollars? It was self-regulating
Right. Well,
at that
that's
point.
exactly right,
Yeah.
because if you put a price on it, then obviously there's going to be a fair bit of self-regulation as to proportion.
I agree.
If you don't have a cost associated with it, then you might as well just have at it to the greatest extent possible.
I wholly agree. And, we're in the personal injury business, so we get medical records, and we're used to this all the time where a Beaumont hospital will contact us and say, well, if you want to go this far back, there's going to be, $4,000 worth of expense on your part, and it self-regulates. We say, can you get us just this?
Right.
And that's how it typically works. But one thing I want to highlight here, Your Honor, is UIA has not produced a shred of a single page of records in response to the cases that are before you. So to me, if that was a sincere concern, I don't want to say it that way, but some records should have been produced, and they weren't. So I guess I just wanted to address that. Rule 9.7 exists. This will be not only self-regulating, but the review magistrate can also come in. They'll apply the standard that this court decides or otherwise make a determination as to what could be relevant. We're keeping in mind that qualifications, training, work experience, all are relevant to disability. And of course, credibility is always relevant. And so if there's credibility issues within the records of finding a witness to be lying or whatever the case may be, that could be relevant. So if I could back up now and just go to the first issue, unless there's any further questions
By the
about
first
disclosure.
issue, you mean whether they have to make any disclosure at all?
Correct, if I could. So work comp litigants have substantive rights under the Workers' Comp Act that are affected by the information that the UIA has. The UIA's current position that they aren't required to produce any records because of confidentiality reasons infringes upon the rights of the work comp litigants. I would say that the UIA's concern for confidentiality is prioritizing the confidentiality rule above the substantive rights of the same work comp claimant and the same work comp employer. I would say also, I looked at the CFRs that were cited by the UIA, and the CFRs in the subsection 2 of those CFRs, they didn't highlight this, but in the subsection 2 of the CFRs they cite, it indicates that a subpoena that is issued by a state government official with authority to obtain such information must, is an acceptable means or exception to the confidentiality requirements set forth by the federal government. Section 418, MCL 41853 gives a workers' comp subpoena the full force and effect of order signed by a workers' comp magistrate. So in essence, the CFRs, and I understand they fund the UIA program. So, but their own CFRs are less stringent of a confidentiality requirement than what the UIA is presently arguing. So I'll make that point there. And then if I could go to what I'm going to call the work comp section, which exception, which is MCL 42111B1I. This is an exception that is very broad. The language, it says information in the unemployment agency's possession that might affect a claim for workers' disability compensation under the Workers' Disability Act must be available. I take issue with the interpretation of the UIA of the Rule 201. They say the term interested party is as used under the act of these rules means anyone whose statutory rights or obligations might be affected. They want to add certain terms. Anyone is a very broad universe. In fact, I have a hard time coming up with a broader universe of people than is created by the word anyone. But what I would suggest is that the UIA is trying to add to the word, they're trying to add anyone who is a UIA litigant to that word, which isn't fair. And further, they want to add to the words whose statutory rights, they want to say whose statutory rights under the MES Act. Now, they want to take the term interested party and they want to say that it is limited by the scope of statutory rights under the MES Act. So after adding the word, they want to say the term limits the statutory rights and obligations under the MESE Act. But that is a very concerning interpretation because there's hundreds of statutes in Michigan law that use this construction. And if that's allowable, then it would, I would think, have significant impact in the interpretation of other statutes. The fact of the matter is, the term, when it says the term interested party as used in the act of these or these rules, that's a contextual modifier that defines the term that's being defined. It doesn't limit the scope. It's talking about usage, not talking about limiting rights. To interpret that differently, to interpret it as the UIA suggests, would have, I think, huge ripple effects on the interpretation of other statutes. So our position is that's a very broad definition. I would agree with Justice Boonstraw with regards to it, the definition of interested party beginning at the end of the work comp section and continuing into the Rule 201, that certainly in view here, the work comp litigant is considered to be someone who meets the definition of interested party and is able to get their own records from the case. It was suggested that we could have this information in other ways. I have found that subpoenaing a claimant's UIA records is difficult to litigants. Litigants don't, work comp claimants don't keep very good records. And even if you can say they can go get that information on the computer, they're not very sophisticated with computers. And to be fair, the work comp claimants aren't under a statutory obligation to keep UIA records, but the UIA is required to keep those records. And therefore it's a very effective source for work comp litigants to be able to exercise their substantive rights under the Work Comp Act. If I can just make a final appeal, I have alone 30 plus motions that have been made at the workers' comp agency with regards to this issue. And there's many defense attorneys just like me who have that many and more. It has brought the workers' comp system to a standstill in terms of us not being able to prosecute these cases because we don't have the information we need. The claimants want us to have this information. They want us to have the information that the UIA has of theirs so their cases can be proceed.
Right. Well,
And this
as
is
you
holding it
indicated,
up.
though, the claimants have ready access to this information. I mean, I know what you're saying about level of technological sophistication and all of that, but I don't think we can make a decision just based on expedience, can we?
You can, and it's a fair question, and I want to bring up the point that this is the first time I've heard any attorney general make an argument that the claimants can get the information online. So I'm responding somewhat without having to check this out myself, but I suspect that the records that the UIA has available to claimants is not all the records that the UIA has that would be relevant to our case. So even if we have a claimant that can get the information online, it's still not all the information that we would find relevant in the case.
So is subpart 3 of the rule part of the definition of interested party under the statute, and if not, why not?
Well, subpart 3 does begin with except as provided in this act. The appellate commission noted this as well. I'm sorry, it's actually the appeals commission now.
I'm looking at subpart 3 of the rule, I'm sorry.
Oh, the rule.
Which talks about chargeable parties and whatnot, which I think is the basis for the Attorney General's argument. That's part of the definition of interested party, which then gets essentially incorporated into statute for.
Okay, the Rule 201
Rule 201 starts out with the broad definition of interested party that you were talking about.
Yes,
And then it continues with other provisions.
yeah,
When a claimant for unemployment benefits is not an interested party, what the interested party's rights are, et cetera.
Mhm.
And then in subpart 3, I think is the basis for the argument that
yeah.
you don't fit the definition here.
Well, thank you for the question, and it's a fair and good one. The way, I agree with the UIA in the position that this has to be read as an entire legislative scheme. And that we need to take the entirety of this rule and look at it. What I see, understanding that the entirety of the rule, is a general definition of interested party in the first sentence, followed by all the rest being specific references to an interested party in a UIA case. And we could say, well, if there was a heading or a separate number, that would be clear, but of course, headings and numbers don't factor into the interpretation. What we do use when interpreting statutes is the words. And I would suggest that the words clearly demonstrate a general definition of interested party in the first sentence, and that all of the subsequent sentences clearly relate to interested parties who are in a UIA proceeding. I would like to highlight the fact that if in fact, and this is very important, if in fact the UIA's position here is correct, and that the only work comp litigants that can get UIA records from the UIA are the way they suggest, it creates two categories of work comp litigants. First, it's workers' comp litigants who have work comp litigation going on and also at the same time have UIA hearing going on. That's category 1. Category 2 is the work comp litigant who only has a workers' comp claim and doesn't presently have a UIA claim going on. That creates two categories of individuals in the work comp world that can get records. The first one can get them, the second can't. I don't see within the Workers' Comp Act or within the UIA Act a reasoning for such a two categories, two populations like that. What I see is a work comp exception that is intended to allow work comp litigants to pursue their work comp cases with the information that is relevant to their cases, and they're able to get it from the UIA regardless of whether they happen to be in a UIA hearing at the time or not. I would say that reasoning, that legislative intent is clear from the fact that we need these records in the work comp realm to proceed forward with the work comp case. And if the legislature intended to have some kind of a two-class system, it doesn't really fit in the overall scheme. So I am taking very much of an approach of looking at this rule in its entire context, general definition followed by specifics, and then also in the context of the two MES Act interacting with the Work Comp Act. I'd have to say that I don't think the UIA gets to act like a silo here. They don't get to say, we're all just right here. There's other acts, including the Workers' Compensation Act, where substantive rights are created based on the information they have. They can hang tight and be in the huddle and say, we're not giving up anything. But the reality is they have, within their statute, obligations to provide to others, other agencies. One really important factor, I think that I highlighted in my brief, but I want to highlight here if I could. If a work comp claimant receives a bona fide offer of employment through the UIA, and they refuse to have that job, take that job, that will bar them from receiving workers' compensation benefits, as you would expect. If someone can work, they should work. And if they were offered a job and rejected it, they don't get benefits. Well, there's only one place that those records exist. I'm not going to get that from the workers' comp claimant. But if the UIA has that record, they can't get wage loss benefits, which the court knows, wage loss benefits are lifelong benefits. So we're talking about a very big exposure, but there may be evidence that helps me as the employer defend that case. And it's only in one place. It's there, and I can't get it unless they give us the records. So, thank you, Your Honor.
Thank you, Mr. MacArthur. Appreciate it. Mr. Gearing, you'll have a few minutes for rebuttal.
Thank you, Your Honors. I'll endeavor to be brief here. I want to start first with the very last point that counsel made on the statutory obligation of UIA to produce information on refusal of bona fide efforts of employment. That statute requires UIA to produce that information to the Workers' Compensation Agency, and then that agency provides that information to the insurers. That's what the statute says. That, in fact, undercuts their argument because there is another statute requiring information, and no one here is saying that the agency isn't fulfilling that statutory obligation and providing that information to the Workers' Compensation Agency.
It doesn't necessarily
So
have to be
the employers don't need it because they've already been given it.
But it doesn't have to be the exclusive mechanism. I mean,
Certainly, I agree that nothing in that statute says that's the exclusive mechanism, but I think its existence shows that the legislature is thoughtful and thinking about these things. And I think it absolutely undercuts the other arguments that he's making. And I apologize, I kind of talked over you there, Judge Yates. Another thing I wanted to note, the reference to Rule 418.89, subsection 7. It says any dispute arising under this rule must be brought through motion to the assigned magistrate and have a copy of the subpoena attached. That is what we did. That is what the burden on UIA is. And there's no dispute that we fulfilled that burden. It says if a party claims certain subpoenaed records are protected from disclosure by a privilege, and certainly that's set forth in all of our motions, it's not the UIA's duty to request another magistrate look at it. It says the magistrate assigned shall assign another magistrate to hear the motion. So that's a requirement of the magistrate. That's not a requirement of the Unemployment Insurance Agency. So that argument, again, is just under the basic text of the statute is absolutely wrong. And just two other very brief things I wanted to note. There was mention of information on qualifications and training that the UIA could have from before the date of injury that could be relevant. I'm not going to stand here and say that UIA would never have any information on that. The number of times and the circumstances in which UIA would have that information are very rare. So unemployment claimants have to register for work, and they do that through Michigan Works. That's what the statute requires. Michigan Works is not UIA. Information that they may give to Michigan Works on like a resume on their qualifications or training, UIA does not have that. Michigan Works has that. And again, so I'm not saying there aren't circumstances where maybe they might, but it's going to be very infrequent. And finally, I just wanted to note, again, if the legislature's intent was for everybody to a workers' compensation case to be an interested party, that's what they would have said, and they wouldn't have referenced the administrative rule at all. And perhaps that does create two categories in a workers' compensation case, but that is a complaint to take to the legislature. And then my final point is my brother counsel is not a government official. When an attorney issues a subpoena and signs that subpoena for a circuit court case, they're not a government official. That argument would absolutely swallow the requirement of federal regulations that the agency has to seek to quash subpoenas where it believes it's seeking information that's confidential. Thank you very much.
Thank you very much. Both of you, all three of these cases will be submitted Let's move on now to case number 22, docket number 372944, Jasmine Murray against Nam Estates Properties AA2 LLC.
May it please the court, Steve Hicks on behalf of the plaintiff appellant Jasmine Murray. As the court knows, this is a premises liability case. I've just got a couple points that I would like to make today. The primary argument from the defense is that my client, Jasmine Murray, does not know the cause of her own fall. Quite frankly, that's not really the operative question here. There hasn't been any allegation.
Right, whether she slipped and fell on snow or ice or something else. I mean, the problem is the missing handrail, right?
Yeah, and that's consistent with how we alleged it in the complaint. The absence of the handrail has always been the issue. And admittedly, she's a little unclear on what caused her to slip. But she's fundamentally clear in her testimony that she went to the right, which is where the handrail in question is located. Her momentum of the slip took her to the right. She used that word, momentum. And that's, she grasped for it. She used that word also. And she was not, there's no handrail there, so she was grasping air. And then she falls. She didn't have a strong recollection of the rest of the fall other than coming back to consciousness at the bottom of the steps, a little to, I believe, a little to the right of the concrete pad in the grass. So that's fundamentally, I think, the key point. This case is a little factually different than
How long
some.
had that handrail been gone that she reached for?
About a year and a half. Well, muscle memory hangs on a long time, I guess. But it'd been about a year and a half that it had been gone. I think the more salient point is that when she moved in, that handrail was there. And she lived there about 6 months with the handrail there, but until it basically fell down and then was taken after it fell down.
There was still, at the time of the fall, a handrail on the other side?
Yeah, there is. There's a little confusion in the record on that point, but as best as I can determine, there was still one on the left side. That's not the direction her momentum took her, so she didn't reach it.
I think the evidence was that it was wobbly too.
Yeah, it was not. It was in poor condition, and when she contacts the landlord about the railing, she's kind of talking about both of them. When are you going to get to this? And they said they're working on it. So this case is a little bit factually different, but I think it's the salient point, and you've already grasped it, is that it's really about an absence of the handrail. Because the question is not really what caused her fall; it's whether that lack of the handrail caused or contributed to the injury that she sustains. And she sustains a pretty serious injury to her left ankle, tibia fracture, medial malleolus fracture requiring surgery. If I can focus for a minute on the trial court ruling and how the trial court resolved this issue. Primarily, the trial court relied on an unpublished opinion. AMBS versus Family
Counseling and Shelter Services.
Yeah, exactly. First of all, I would obviously note that it's unpublished, so it's not precedential for this court. But I think it's also a questionable authority because if you read AMS, there's the discussion of the facts in that case, and the facts are slightly different there. The plaintiff actually says she could not remember how she fell. She doesn't talk as much about, whereas my client talks about the mechanics of her fall much more specifically, I think. So there is that factual distinction.
I think the larger problem with AMS is that it seems fundamentally inconsistent with Candle El Said. I mean, the world changed.
Yeah, absolutely. And it's hard to read AMS without understanding it as an open and obvious decision under Lugo. So yeah, I've also made that point in my brief. In addition, there are some contrary opinions to AMS, and I've pointed those out to the court, both published pre-1999 opinions, Mills and Davis, that deal with handrails that reach different results and reverse similar summary disposition rulings, and also a couple unpublished opinions that I've cited. So I think that is the fundamental problem with the trial court's ruling in this case, is the reliance on the AMS case as being the deciding factor.
Right. I mean, the trial court lifted entire portions of AMS and essentially said, AMS is like this case, AMS
Yeah.
is like this case, again and again.
Read directly from the opinion, and read one paragraph that talked about mechanics of the fall, and I addressed how I think our case is factually different, but then went on to quote a whole paragraph that is no longer good law.
Right.
In Michigan. I think that was the most glaring error with the trial court's decision. So, having made those points, unless the court has further questions, I just ask that you reverse.
Thank you very much.
Thanks
You'll
very
have
much.
time for rebuttal, Mr. Hicks. That's fine. You can set the playing field the way you want.
Right, there you go. Thank you. All right. Good afternoon now. Kaylin Piper on behalf of the defendant appellee here today. The trial court properly granted summary disposition to the defendant for two reasons. First, plaintiff cannot state beyond mere speculation and conjecture what caused her to fall and her injuries, and the lack of a handrail on the porch of the property is not a dangerous condition. I'd like to just take a step back and talk a little bit about some important facts that we have here today. So this alleged fall occurred at a single unit property. So this is not an apartment complex where we have multiple people traversing up and down this set of stairs. There's no dispute here today that it was her obligation under the lease to maintain that porch free from like snow and other conditions, ice, things of that nature.
Well, we know that this happened in January, right?
January
And
12th,
I think
yes.
you're the one who submitted the picture of it, and whatever value that has, it makes it clear that there was snow and ice all over the place, right?
Yeah, so admittedly, the picture that was submitted is exemplary. It's not the exact date, but that it had occred. But
I got it. Yeah,
right,
believe
right.
me.
But
Well
you
aware of
know,
that.
there's no question that there was snow and ice that day because I believe she testified that her high school son, which is hard to believe on my end, but went out at 4 a.m. and shoveled the front porch for her that day. So that's lucky for her. So, with that, we have this front staircase. We've got a front door that actually opens to the right. If she's facing outwards, leaving her house, the front door actually opens out to the right. We've got,
When you say the right, it looked like it'd be her left because it swings open that
it's
way.
actually the opposite. So she pushes it out to the right. The side where the handrail is not present is the same way that the door opens. Then we have a handrail to the left.
Yep. Right.
That's not really an issue here today. And it's correct that the handrail, per her own testimony, had been missing for about 1.5 years.
Right. As a matter of fact, there's a text from just a few days before the fall where she says, would you please take care of this thing?
Right, right. But it's been 1.5 years, it's been gone. So it hasn't been there. Very important to this case. And I understand the argument that, what caused her to fall, is a position that I'm taking here today too. But most importantly is when I asked her about how she fell. I can't tell you how I fell. I don't remember that. So she's asking to take this case before a jury and say, all I know is that my momentum took me to the right and I landed on sort of that side of the porch. It's actually to the front right corner. But we don't know if that handrail, it was never tested, if that handrail would have even prevented her from falling if it was there. And we don't know if she's falling to the right, is she falling backwards to the right? Can she even grab onto the handrail? So those are all questions and we're asking a jury to guess. In fact, we're all guessing. The plaintiff herself is even guessing. She doesn't know. All she knows is she landed.
What bothers me the most about the case is the heavy reliance on AMS in the trial
Sure.
court's decision, because AMS is not good law, particularly for what the judge cited.
Admittedly, I was not pleased to hear that when the judge went on into the open and obvious argument. But that's
Right.
in AMS, that's kind of a step 2 in my view of the AMS opinion. Because before we even get to that point, and obviously that's a different analysis under the Kandil El Sayed case, open and obvious still does remain. I think we're all in agreement with that.
Right, but that's something for the jury to consider now.
It remains for defendant's breach and whether plaintiff was comparatively at fault, sure. But before we even get to that point, that case, Kandil El Sayed, still affirms the proposition that, so as an invitee, which there's no question here, plaintiff was, The duty that was owed is reasonable care to protect invitees from an unreasonable risk of harm caused by a dangerous condition on the land. The lack of a handrail in this set of facts is not a dangerous condition on the land, particularly when the law doesn't even require a handrail to be present here, because we don't have the number of stair risers needed under the residential code, the height of the porch itself. None of that actually
Right.
requires a
Right,
handrail.
but if you put something in, you have to maintain it in decent condition, don't you?
But this, sure, and I don't disagree with you there, but that is a different scenario. If she had reached for a handrail that was wobbly, let's assume it was the left side,
And it gave way.
and it gave way and then she falls, that's a different set of facts. Here we have a condition where the landlord just didn't replace it. He didn't have to replace it. The law didn't require him to have a handrail there. And it had been gone for a year and a half. It wasn't gone for only a day or 2 weeks or anything like that. A year and a half's a long time. And she continued to live there. And we have a side door that she could have used, a back door that she could have used. And I know that that's maybe falls under an open and obvious and
Right, I mean, that's
type of argument,
classic,
but
whether it's unavoidable or not.
sure,
That's,
sure.
that's not the law anymore.
Sure, but we have a scenario where it's a year and a half. It didn't require, the law did not require it to be there. So the lack of a handrail when is not legally required does not create a dangerous condition, and nor does it create an unreasonable risk of harm. The cases cited.
As a matter of law?
As a matter of law, the cases cited by the appellant here, particularly the Davis case, handrails were required by law, and that's what's factually different here. The law required handrails on the set of stairways.
Well, but what I mean is you want us to make a determination as a matter of law that this was not a dangerous condition.
Correct. The law,
Not leave it to the jury to decide that.
well, the law did not require a handrail to be present. And again, it goes back to my first argument. We don't know if, even if the handrail was there, if it would have prevented her from falling. So unless this court has any additional questions for me, I respectfully request that this court affirm the trial court's opinion and order. And
Thank you,
Thank
Ms.
you.
Piper. Thank you very much. Mr. Hicks, you get the last word.
I think the only thing I'd say on rebuttal is I do think it's important factually that when she moves in, there's the handrail, and then we lose the handrail during the course of the time that she's renting it. And the reason that's important is the experts are basically in agreement on this, that the handrail is not required based on the risers. It's not required based on how high the landing is. It's required because you put it in.
Right. If you
yeah.
install something and then it falls into disrepair and becomes a dangerous condition on the land, you can't avoid liability by simply saying, well, we didn't have to do it in the first place.
We waited long enough that it fell over. So that's really all I have, unless the court has questions. Thank you.
Thank you so much. Thank you both. And thank you for your patience. I know you've been sitting there a while. That case is submitted. Let's move on now to case number 23, docket number 374708, Erica Elizabeth Bryant against Terrell Nathan Bryant. This is an odd situation because, Mr. Gentry, I know you're here to stand for questions. Mr. Bryant is representing himself, and he sent us kind of an interesting motion saying that first he'd like us to adjourn the oral argument because he was unavailable today because he had to drive someone to medical appointments.
Yes.
And he told us he'd be available in January. Well, that's obviously not acceptable, and we denied that motion. He also asked to appear remotely, but it seemed that he wouldn't be available today. Nonetheless, I don't know whether he is.
Hi, judges. Mr. Bryant is in the gallery.
He is.
Yeah.
Well,
So I think his status is that he just gets to stand for questions as well. So why don't we let him in? And although he has no right to appear for oral argument, I guess we can see if anyone has any questions. Good morning, Mr. Bryant. Can you hear me?
Yes, I can, Your Honor.
All right. And I know you know that we weren't able to adjust the date of the oral argument. I just want to explain that briefly. The three of us are from different parts of the state. We sit for 2 days and we have no ability to just get together at some future time. There are 25 of us on the court. And the idea of getting the three of us together for any future oral argument is essentially impossible. So that's why we denied your motion. It had nothing to do with you or your request or anything else. Now, it's my understanding that you're here to answer questions, as is the attorney for the other side. And so what I'd like to do is see if anyone has any questions. I'm going to have one, but let me see if my colleagues have any before I ask you the one question that I want to ask you. Anybody else have any
I
questions?
don't have a question right now.
All right, let me give you an opportunity to say something about the attorney fees in this case, because as I understand it, there was a substantial award of attorney fees. And I don't think that you were ever really heard on this. Can you just tell me what the status of the attorney fee request was?
The status of the attorney fee request was that I pay $1,400 in attorney's fees to my ex-wife's attorney for work that she did because the court ruled that my action bringing forth a request to alter parenting time and visitation and to obtain joint legal custody of our son was a frivolous action.
Okay, so just hold on a second, because I think in what you said, you answered the question that I should have asked, but I asked a bad question. You've already paid the $1,400 sanction, is that correct?
That is correct, Your Honor.
Okay, that's all I wanted to know. I just wanted to know what the status was of that payment. Okay, now let me give counsel for the opposing party an opportunity to approach the lectern. You, Mr. Gentry, also are here only to answer questions. So let me see if my colleagues have any questions.
I don't have any.
So can you just say a few words about the sanctions award? Because it seems like it was based on a determination of fault, not need. In other words, in divorce cases, the trial court has the opportunity to impose attorney fees either based upon need because the other party can't pay, or on fault because somebody did something wrong.
It's a 600.2951 frivolous finding, Your Honor. And Oakland County is weird in so many senses. In this particular case, what it does is it sends you to the FOC for a pre-screening. And that happened twice here. And my understanding from what the court said on the record is the FOC referee said twice, this is invalid reason under Rodvarka. This is a frivolous motion.
Right.
And she came to the trial court, or he came to the trial court. Now, at that point, if Your Honors hold that there was no prior finding against him to make it frivolousness, Your Honors can hold that. I can't say, all I can say is that the referee told him. I can't say that there's a prior holding the record.
Okay.
And I can't say anything about Smith versus Carrari except that it wasn't raised.
Okay. Thank you very much. I
Thank you,
appreciate it. Thank you very much, Mr. Bryant. Thank you, Mr. Gentry. I think we understand the case very well. Mr. Bryant, I can tell you that our practice is that you'll get an opinion in the next week or two. Okay?
Thank you, Your Honor.
Thank you very much for being here. Thank you, Mr. Gentry, for standing for questions as well. That case is submitted. And at this point, Mr. Bryant, you can go ahead and log off. Thank you very much.
Thank you.
Thank you. All of the remaining cases do not have anyone endorsed for oral argument, and I see no one in the courtroom, so I will just call them one at a time. Case number 24, docket number 369817, in re Crane Henrich Miners. That case is submitted. Number 25 actually has two consolidated cases, docket number 374203 and 374204, in re Gutzman Miners. Those two cases will be submitted. Docket number 26 I'm sorry, case number 26, docket number 374854, In re Foot Miners. That matter will be submitted. And finally, case number 27, docket number 375633, In re B. Surgison minor. That case will be submitted. With that, we have completed the case call and we will adjourn the proceedings and proceed to conference. Thank you very much.